Good afternoon, everyone. My name is David Watt. I'm an audit partner with KPMG, and I head an insurance practice, and I'll let my esteemed colleagues introduce themselves.
Good afternoon, everyone. Is it on? My name is Rob Humphreys. I'm a corporate lawyer with more than 10 years' experience. I'm also an attorney in the insurance group at local law firm Solomon Harris, specializing in insurance, reinsurance, and all matters captive insurance.
Hi, good afternoon, everyone. My name is Raz Basari, Deputy Head Insurance Division, CIMA, and I have approximately around 20 years financial services experience.
My name is James Trundle. I'm a Client Services Manager with Artex Risk Solutions, insurance management company here in the Cayman Islands, and I've been in the captive insurance industry now about 13 years.
Okay, well, thanks for that, gents. I think to get started, we'll start with Raz giving an overview of CIMA news and developments.
Okay, in terms of the items agenda there, we have quite a few things to get through, but quite quickly I'll start off with a few new developments. One of the things we're quite proud of this year is we've been able to recruit and retain quite a few quality staff. Now, some of you would know, if you were here last year, that we announced that we had appointed a new head at the time. For a while, we were without an insurance head, and then last year we were able to appoint Ruan as our new head. Those of you who know Ruan would know he was the other deputy head within the division. So obviously when he became the head, that created a vacancy for the second head. So I was the head of the division for 1 year on my own, but great news, we've been able to appoint Susan Sadler as the other deputy head. She comes with loads and loads of experience, over 10 years regulatory experience. She was previously our reinsurance expert, our reinsurance specialist, and her main role has been focusing on the big B3 applications, the more complex applications where the insurers are not pure captives, they've got a lot of unrelated third-party risk, and she's brought a lot of experience in that regard. So we're quite happy with the recruitment of Suzanne.
I think that was a welcome recruitment too, in light of the constant growth in B3 and reinsurance and more third-party business being done. So CIMA is definitely in need of some additional support and experience, and it's a very welcome development.
Thanks for that, gents. And I guess next we'll have Raz again give an overview of CIMA's philosophy and sort of stance on regulation generally, and sort of the participation that they have across the industry with various industry stakeholders.
Okay, further on we'll go into quite a few regulatory changes that we've made in terms of rules and regulations and the statements of guidance. But just before we get into that, I think it's important that we do talk about CIMA's common philosophy and what we're trying to achieve here. So the few regulatory changes that we have made are all committed towards making sure that we provide regulation that's robust. However, that's proportionate to making sure that we're the leading number one captive jurisdiction. Now, a lot of effort goes towards when we issue statements of guidance and when we issue new rules, but for us, we look at quite a number of factors. The cost-benefit analysis of actually introducing those new regulations, the impact it will have on our regulated entities, and we then come up with what we believe will be a win-win for all parties. Now, very close to that too is making sure that we bring in the right staff. As I said earlier, we brought in a new deputy head. All this recruitment is beginning to yield quite a lot of dividends in terms of us being able to meet with captive owners, meet prospective captive owners. One of the great things about our jurisdiction is, as a regulator, we spend a lot of time meeting with boards of captives. which kind of distinguishes us from a lot of the other jurisdictions. And I have joked about this in the past, and it might sound funny, but it really isn't. I've worked in a few jurisdictions before where the only time you get to see the regulator is when you're being fined or when you're in trouble. And, it kind of amazes me how much people really want to come and see the regulator here, which is a great thing. So having the staff to be able to do that is great. It's also improved things like our response times. We're very, very proud of the fact that, we get back. This is something we've always done, but we've been able to enhance that in terms of being able to get back to insurance managers or captives or any other insurance company by that fact in a very prompt and responsive way. So we continue to have this open door policy where we're transparent, we like to see people, and as long as you have something to share with us, as a regulator, no regulator likes surprises, so we continue to be responsive and open and transparent, and that's basically our main philosophy. The other great thing about being able to recruit the kind of people we want is we're beginning to get quite a few young, talented Caymanians coming through too, and that's beginning to kind of show in the quality of other staff we're bringing on board.
I guess, Raz, just if you could speak to the concept of proportionality and sort of how we see that play out in the industry and how we distinguish between sort of B1s, B3s, Ds, and As, and just sort of give some flavor, because there are some individuals in the room that will be new to the concept of proportionality.
Okay, yeah, very good. Yeah. The whole concept of proportionality, you'll hear a phrase that we use quite a lot in terms of nature, scale, and complexity. Now, it's very difficult to write a rule book or legislation where you kind of split it into various sections depending on the kind of license.
One size fits all approach.
So what we try and do is we put out our rules, obviously where before that we consult with the relevant trade bodies and industry, but what we always say is these rules are based on the nature, scale, and complexity. And a typical example would be, and we're going to talk about this in more detail later anyway, is the anti-money laundering regulations. Now, we would say companies need to have internal controls in place, but the kind of internal controls we expect a pure captive to have for anti-money laundering would be definitely different from an insurance company that sells life business, where the risk is considered to be higher in terms of possible money laundering or terrorist financing. So it's very much based on the nature, scale, and complexity of the business and the amount of business you do.
Okay. I guess the next topic for discussion, Raz, and any of the panelists that want to comment on this, is the reasons for what is the IAIS, why we're involved, and sort of how do we see this as a benefit to the jurisdiction as a whole?
Okay. Yeah. We are members of the International Association of Insurance Supervisors, as well as quite a few other international regulatory bodies and standard setters. So we're members of the Caribbean Association of Insurance Regulators, CARE, and quite a few others. Now, the reason for this is, first and foremost, you want to be at the table with decision makers to make sure that when final rules and regulations and standards come out, they're favorable to you. They consider the pros and cons that apply to the nature of your business. And again, an example would be the regulation of captives. It is very likely that you go to an IIS meeting and quite a few other participants there are very conversant with your standard insurance company, but I do not know too much about captives. And when they try and apply laws equally, you'll have to be there and say, well, that shouldn't really apply to a captive because they're really insuring their own risk. They don't have the third-party risk. They're not commercial carriers like the other insurers. And not only does it enable you to contribute to the debate? It also gives you credibility where people see you at these meetings. They take your jurisdiction and your regulation quite seriously. So for us, we very, very keen to be part and parcel of these associations. However, saying that, what we do not want is to be unnecessarily front runners of all the rules and regulations that come in. What we do is we consider these, see how they fit into what we do, and apply them in a proportionate manner.
Okay.
So I think we want to be seen as compliant with best international practice and best international standards, but noticing that the Cayman, the captive industry is very different to the rest of the open market insurance industry, and have a proportionate but appropriate response and regulation of that.
Very much so. Just as a flavour, we're part and parcel of the executive committee of the International Association of Insurance Supervisors. We're on the governance committee. I attend the market conduct working group. The head of insurance attends the reinsurance group. So we're parcel of quite a lot of these working groups, so that we can not only influence the agenda, but make sure that we're at the top tier of regulated and well managed jurisdictions.
Okay, thanks for that, Russ. I guess as we move on, we're going to be moving into sort of the meat of the presentation when we talk about the various new and proposed regulatory changes, the statements of guidance. I guess the first one on the agenda would be the SOG relating to the retention of records. Raz or Rob, do you want to sort of take us through what those changes will mean for the industry?
Okay. Yeah, it's fair to say that when we do change a rule, or when we introduce a new rule, a new statement of guidance, there are a number of reasons for this. One is what I've alluded to earlier in terms of our international obligations as part of the International Association of Insurance Supervisors. The IIS issues insurance core principles. So sometimes, to make sure that we comply with these insurance core principles, we might issue new statements of guidance or new rules. But sometimes it might also be a reaction to what we've seen out in the market when we do on-site inspections or through other desk-based kind of activity. Now, in terms of the nature, accessibility and retention of records, what we're trying to achieve there is to make sure that captives and other insurers keep adequate records, they're accessible, and that they actually retain these records. Now, one of the things that we did notice throughout the year, this was issued in August 2017, one of the things we noticed throughout the year was, in some cases, and I'll emphasize that this is just a few cases, there were a few insurance managers that did not have access to books and records of the captives. Now, whether this was the captives not giving them access or them not demanding it, we were not happy with some of the findings there. So this rule is to make it, statement of guidance is to make it crystal clear that insurance managers need access to those books and records, and they need to retain those so that when we go out and do our inspections, we can actually look at these. And I'm happy to say, since this has been issued, we have seen quite a lot of improvement in that regard. Now, very close to that too was the statement of guidance on the roles and responsibilities of insurance managers, which was issued around the same time. And again, this was just to buttress the point that insurance managers, where you have a captive, it does not have a physical presence here. The whole premise of us allowing captives not to have a physical presence is that they have an insurance manager that manages the day-to-day, that has access to books and records. So we were just making it clear so that insurance managers totally understand the roles and responsibilities. Now, we've had a few other as I said earlier, it has been quite a busy year. We have had other statements of guidance and other rules and regulations. For example, during the year, we issued a regulatory policy on the exemption for an audit for our Class C licensees. Now, our Class C licensees are those involved in investment-linked or insurance-linked securities, and they tend to be fully collateralized investment vehicles linked to insurance. And there was an argument for whether they need or do not need an audit. But more importantly, what we also did was we looked at what other jurisdictions do. And there are quite a few jurisdictions that do allow an audit waiver. But more than just the audit waiver, what we also did was we used that opportunity to look at our response times in dealing with such applications for a Class C license. Now, the way these vehicles are structured, there is a huge need for expediency. And we noticed that some of the other jurisdictions were dealing with some of these kind of applications within 5 to 10 business days. So we revamped the way we look at the Class C licenses, and within this new regulatory policy, we now deal with most of these applications within 5 business days. So that's a typical example of where we go out, listen to the industry, and revamp and revise our practices based on what the industry is telling us. We don't always say yes, but where we can, we tend to.
And on increased competition from other jurisdictions.
Definitely.
Raz, can I? I'll just jump in very quickly. I think the Class C licenses, although it necessarily isn't applicable to a lot of people in this room, I think it does. It's a testament to the fact that CIMA is responding to queries that are coming from the industry and from IMAC in general, in the sense that these were things that IMAC looked at and said, you know, this would be great to put us on a par with other competitive jurisdictions such as Bermuda. The response time to actually looking at those license applications and pushing them through, and also the concept of an audit waiver. However, in regards to the audit waiver for those types of insurance companies, the majority, I would say, of those licensed entities under the Class C license in the Cayman Islands actually do not want an audit waiver. There will only be a few that will actually take that up, and largely because it's an internal legal requirement of the actual sponsor of those transactions that they take, that they actually have a financial statement audit. So obviously that would be music to David's ears that, you know, that's not going to be the case. And then if I can just backtrack ever so slightly as well, just going back to the statements of guidance on record retention and insurance management, insurance managers, obviously those are things that insurance manager one is obviously quite close to my heart. But in terms of both of those, and I think they're quite linked in really. I think what CIMA's trying to achieve on both of those is essentially get away from the idea of the insurance manager just being a post box on island, effectively rubber stamping policies without actually any true access to the information and actually true, like, record keeper actually dealing with preparation of financial statements, having the policies, the insurance policies, kept in-house, whether electronically or hard copy. And it's trying to move away from that concept of simply an insurance manager just really being a PO box. And it's something that I think the records retention policy is also trying to address as well. And really, if you're a captive owner here in this room today, this is something that really you should be seeing just slotted into your policies and procedures that would be approved by the board on an annual basis. Rob, any other points?
Yeah, I think just on the statement of guidance and responsibilities of insurance managers, I think that was actually an update to a previous version that had been issued, I think it was more than 10 years old. Yeah. And it's just testament to how, you know, Cayman has changed and how the regulatory environment has changed both in Cayman and globally. You know, the statement of guidance for responsibilities of insurance managers that would have been applicable 10 years ago, and the sort of, you know, the way in which insurance managers were conducting their clients' business and assisting clients 10 years ago has changed quite significantly. So it's, I think, a welcome update to try and give some direction and be helpful to insurance managers as to what CIMA really expects from them in terms of the services they're providing. And just to touch on a few points that are contained in that statement of guidance, it's really designed at setting out CIMA's minimum standards, minimum requirements for those for managers. It is, again, related to the nature, size, and complexity of the clients of that particular insurance manager. So the more complex your client, the more requirements and oversight there's going to need to be. It also points out that insurance managers have got obligations both to their clients, as a fiduciary sort of relationship there, but also to CIMA. Insurance managers serve as a sort of a go-between between CIMA and the ultimate clients. A few other things just to watch out for in that statement of guidance. It does require that insurance managers disclose to CIMA any sort of material events with their clients that CIMA would ordinarily want to know about. So that's about the communication between the insurance manager and CIMA. CIMA wants to be kept informed. They want you as insurance managers to be communicating with them and bringing to their attention any concerns that they might want to know about. The other thing that I noticed too, just reading through the statement of guidance, is it also sets out the requirements that CIMA expects to be contained in the insurance manager's management agreement with their clients, and exactly what that management agreement should address. So for those insurance managers in the audience, if you haven't done so already, go and take a look at the statement of guidance and compare what those requirements are with what you already have in your management agreement, and if needs be, just update it accordingly.
I guess, Raz, do you want to touch on the anti-money laundering regulations as well and just sort of talk about the guidance notes in relation to that?
Definitely. I mean, going back to what I said earlier, this year has been a busy year, but a lot of what we've done this year has been within the anti-money laundering realm of things, where some of you might know that next week the jurisdiction will be subject to a FATF inspection. That's the Financial Action Task Force. Now, they issue 40 recommendations to various countries, and everyone is required to comply with these 40 recommendations. And they mainly deal with, recommendations as to how to combat and forestall money laundering and terrorist financing. Now, as part of this assessment, we've looked at, reviewed our money laundering regs. So the old money laundering regs were called the Money Laundering Regulations 2015. Now, the name's changed quite slightly. It's now known as the Anti-Money Laundering Regulations, which I think it should have been from the outset. I was a bit so someone kind of noticed that, and it's now the Anti-Money Laundering Regulations 2017. And they were issued on the 2nd of October now. What we've done is made sure that one of the recommendations of FATF, something that's been introduced quite recently, is a risk-based approach to anti-money laundering and the controls you have to put in place. And one thing you'll find within the new regs is re-echoing that concept of a risk-based approach. And one of the things we kind of say for captives is low risk does not mean no risk. We appreciate the fact that it's very unlikely that someone will set up a captive or use a captive for money laundering or terrorist financing, but it's not impossible. So you still have to assess the risk and put some systems and controls in place. Very closely linked to that too is a set of guidance notes. The guidance notes are there to kind of explain our expectations within the money laundering regs. So the guidance notes are basically our minimum expectations for the anti-money laundering regs and how you comply with that.
And there are this sector-specific guidance notes as part of that too. So I think there's a general guidance note, and then for the various sectors within the financial services industry, including insurance, there are specific notes that apply.
Exactly.
The big question, though, Raz, I think is do the anti-money laundering regulations apply to captive insurance companies, and if so, how? And I think they are just, they've just come out, and we've all been taking a look at them and trying to decide exactly what the application is. I don't know if you want to comment on that.
Yeah, it's one of those kind of funny yes and no answers, because Technically, no. The way the money laundering regulation or anti-money laundering regulations have been drafted, they refer to relevant financial businesses. So relevant financial business relating to the insurance sector only covers those doing life and annuities. So
Long-term business.
Long-term business. Those writing general business are not caught under relevant financial business. So the phrase we use is that they do not apply directly. We then start with the big however. You still have to have systems and controls in place, because what we do not want to do is say, because the money laundering regulations do not apply directly to those carrying out general insurance, that they then decide not to put anything in place. We'd still expect the bare minimum in terms of assessing the risk. Because if you look at some of the other regulation in place, for example, the risk management rule for insurers and the internal control rules, they all talk about maintaining risk registers, understanding your risk, things like AML risk and various other risks. So even if we say the anti-money laundering regulations do not apply directly, under things like the risk management rule, you'll still need to consider potential AML risk anyway.
For those,
These recommendations and guidance are not law. Why wouldn't you put these into the law?
Yeah, it's the way things have always been drafted. What you'd find nowadays, there's another piece of legislation that was drafted around the same time as the anti-money laundering regulations, called the Proceeds of Crime Law. So the Proceeds of Crime Law 2017, there's a section within the Proceeds of Crime Law that mentions the kind of weight given to guidance notes, and it gives an example of where if someone is to be taken to court for non-compliance with the anti-money laundering regulations, it states that the courts will consider as to whether, trying to decide whether someone's guilty or not guilty, they will consider whether the individual concerned has complied with the guidance notes or not, or taken the guidance notes on board. So yes, they are guidance notes, it is guidance, but they're bare minimum expectations, and they're almost backed by law when you look at that kind of example where the courts themselves within the Proceeds of Crime Law state that they will look at guidance notes to determine whether someone's guilty or not.
Yeah, so you're not going to be found to be in breach of the guidance notes, but if you are found to be in breach of the law, and the guidance notes inform what is set out in the law, so that's something that the courts or regulators will take into account when assessing whether or not you're in breach of the law itself.
And I guess just from an audit perspective as well, if SEMA's issued guidance notes and we find that captives are in breach of those guidance notes, we almost view that as an issue of non-compliance. So it will be raised from an audit perspective as an issue of non-compliance, whether or not it's law or an SOG.
from a captive owner perspective, a lot of these, and we've talked about how it's not necessarily applicable to the captive industry. However, certain controls need to be in place. If you have a captive insurance manager engaged on the island, they really should be handling that process, getting all that documentation that is required in place. And really, from a board perspective, it's the board then who will be reviewing that and approving it at board meetings.
Yeah, and rather than that being an obligation in terms of anti-money laundering regulations, it's an obligation or guidance has been given by SEMA as a regulator in terms of statements of guidance on, or regulatory policies on internal control. So even though the AML regulations might not be directly applicable to insurers, insurance companies and managers still have to comply with those the statements of guidance that have been issued by the regulator themselves. Which essentially require you to maintain the same sort of information that the law would in any event.
Definitely. And I think it's, again, very important that we stress that even when we do issue these new rules and regulations, it's very much on a cost-benefit analysis basis where we look at the pros and cons, we consult with the industry. So at the moment, the guidance notes are actually still being consulted on. So if you do have a copy of the guidance notes and you do want to comment, you've still got up to the 29th, which is today, really.
Yeah, you got till tomorrow. I think.
Tomorrow.
Yeah.
Tomorrow.
They're about 120 pages long as well, right?
So we've all had to go through them.
Still got up to tomorrow to get your comments in. So
I think the hope there is that we might see some amendments to make it clearer that it's only life and annuity and long-term business that's directly, directly caught by the regulations, and the general business, of captives would not fall subject to the regulations. Although again, the statements of guidance and regulatory policies would still apply.
Okay, gents, we're running a bit short on time, so we're going to try to speed through ICP 18 and 19, I guess, and just talk through the update to the rule on conduct of business.
Yeah.
Raz, you want to just get started there, and anyone else can chime in?
okay, this one we added to it does not directly apply again to a lot of the captives. We do have a lot of our B3 insurers, i.e. those that are in the B space, however, they do a lot of unrelated business. Now, we've got quite a few B3 insurers that do life business, and obviously we've got our domestic market, the Class A insurers that do life business. Now, I mentioned earlier that the IIS has certain insurance core principles, and from time to time they revise these. Now, at the moment, the IIS is currently revising ICPs 18 and 19. ICP 18 is for intermediaries, so i.e. your brokers and agents, and ICP 19 relates to market conduct. Now, one of the things the IIS is working towards is moving away from the use of unlicensed intermediaries. At the moment, insurers in Cayman can use an unlicensed intermediary.
That would be in another country, possibly where they're not licensed in that jurisdiction, nor is the insurance business.
Exactly, and a typical example would be where you conduct business in Latin America, I don't know, Peru, and a few Chile, other countries, and you have agents in those countries soliciting business for you, and those agents do not necessarily have to be licensed. Now, what the IIS is saying is all intermediaries need to be licensed because there have been quite a few drawbacks from the use of unlicensed intermediaries. But again, this is early days. The rules are more or less finalized, but it still needs to be ratified, and based on that, we've started looking at our market conduct rules, making a few changes, and we hope to have new market conduct rules in place by early next year. However, as I mentioned earlier, it should not affect the B insurers unless the B insurers are actually doing life and selling to retail customers.
So usually B3s who are involved in life and annuity business, and that's a limited number of Cayman insurers.
Definitely. However, we are seeing quite a lot of growth in that area. We've seen this year we've had 29 new licenses so far, and quite a number of those, I don't know the exact number, but quite a number of those are actually in the B3 space, especially with people doing life and annuity business.
I guess, Raz, just speaking to that, what do you think is driving the majority of that growth on the life and annuity side?
I just think it's a growth area in terms of, especially when you look at markets in emerging markets where there's a need for life cover. Many of them are not kind of offering these products in the Western world. A lot of the growth is within emerging markets.
And I think Cayman offers an experienced regulator and an appropriate but proportionate regulatory and business environment to do that business.
Definitely.
Okay. And I think we're going to move on to the next sort of primary topic today, which is FATF, the update, and then Raz, if you can speak to what is FATF. I know it's been keeping you guys up at night over at SEMA. Okay. If you can speak to it and sort of tell us what the genesis is for it and what the implications are for the jurisdiction.
Okay. Yeah, as I mentioned earlier, we are subject to a FATF review. FATF means the Financial Action Task Force. Now, it also has various regional bodies or associate bodies, and the Caribbean region has its own body called the Caribbean Financial Action Task Force. Now, they'll be carrying out their assessment of the jurisdiction between the 4th to the 15th of December, and this affects the jurisdiction as a whole. So they'll be meeting with representation from SEMA, but they'll also be meeting with people from, the Attorney General's office, the Ministry of Finance, the police, Customs and Excise. They're looking at banking, asset management, investments, insurance, trust. It's an assessment of how the jurisdiction goes about implementing the 40 recommendations that FATF has laid down for various jurisdictions. Now,
I should jump in and ask, Raz, why is this happening? Why is this happening now? Is it because we've done something wrong, or is this a scheduled and regular assessment? And what's been the history in terms of previous assessments that have been done?
Okay, no, it's very much just a follow-up visit. It's called a mutual evaluation. Now, this is the 4th mutual evaluation where we get evaluated by our peers. We've had 3 in the past. The first one dates back to 1997. Then we had one in 2002, and the third one was as far back as 2007, so 10 years ago. Now, all those ones have come out quite successfully. We've done pretty well. This one's a bit of a different one in that there's a new kind of slant to it. Most of the evaluations are very much looked at what's known as technical compliance. This has 2 components to it: technical compliance and effectiveness. So technical compliance, they look at your framework. So does the jurisdiction as a whole have the right framework in place? I.e., does it have the rules, regulations, and they look at, how we go about responding to acts of terror. For example, within the jurisdiction, within Cayman, we have a money laundering steering group, chairmaned by the Attorney General. You've got the MD of SEMA on it. You've got the police commissioner on it. You've got the head of Customs and Excise, various parties. So in the event of a terrorist attack, we know exactly how to respond and what to do. Now, the second part of the assessment is effectiveness. How effective are the various rules and regulations? How effective is our framework? Do they do what they say on the tin? This is where they now meet with various people. They'll meet with representation from SEMA, representation from the industry. Quite a number of our licensees have been scheduled to meet with them. They'll talk about their procedures, their processes, and things like whether they've actually filed suspicious activity reports and the process in doing that to decide whether our regulations are effective. So this is very outcome-based. It's very much outcome-based, and they have something like 11 immediate outcomes, and they assess us against these immediate outcomes as to whether we're performing the way. It's a regular thing, but going back to David's question about the knock-on effect of non-compliance or why this is so important, it's very important in the fact that the jurisdiction does not want to appear on some kind of grey or blacklist as being non-compliant, because what that means is it just makes the jurisdiction harder and costlier to do business with. Now, just look at it this way. If you're a company and you want to do business in a country that's been labeled as non-FATF compliant, it means you have to do extra due diligence, more compliance resources and everything. You might as well just easily go to a jurisdiction where you don't have to do as much. So those assessments do carry weight. It's very important that we all club together, which is what we are doing, to make sure that we can demonstrate that. And we do a lot. We've got the all the regulations in place. and we continue to carry out quite a lot of activity in that regard. Now, I know I'm running out of time.
No,
so-
that's fine. I mean, we'll shorten it if we need to. But I guess, Raz, on this topic, because obviously the administrative fines have been a point of focus, I think, for the industry as a whole. Can you speak to how we're now aligned, or sort of what's happening in other jurisdictions? Are we doing anything different? Are we pretty aligned to what we're seeing in other jurisdictions?
Okay, no, brilliant question. Now, on the third mutual evaluation, which dates back to 2007, one of the things that they did bring up, that FATF brought up, was the fact that we do not have a strong enough deterrent for people in terms of non-compliance. Now, we do have obviously quite a lot of strong rules and regulations around things like if a company's being run into the ground or it looks like it's going to be insolvent, we can put in controllers. If a company's non-compliant, we can issue a cease and desist order, we can issue warning letters, various controls and kind of actions that we can take. But one of the things they have said is we don't have that middle ground where, you know, a quick and effective way of dissuading people from non-compliance like an administrative fines. Now, most jurisdictions and most of our competitors have these, so it is something we're looking into. The rules are in place. It hasn't been effected yet, but we're just waiting for the nod now. Obviously, we've received a lot of feedback on this, and people concerned that, does that mean they'll now start getting fined? Well, if you're compliant, obviously you will not get fined. The intention is not just to dish out fines, and even what we do at the moment when we go out, do our on-site inspections, we'll go out, issue a report, and give people adequate time to carry out whatever corrective action we've mandated. We very, very rarely, and it's not our intention to, you know, crack a nut with a sledgehammer and start imposing fines. That's not what this is about. It's something that FATF has identified as a weakness and we need to comply with.
And I think on that point, you're likely, CIMA, I suspect, from a regulatory perspective, will be looking for serious offences and looking to enforce, you know, against that low-hanging fruit, if you like, rather than smaller, you know, less concerning and pettier offences.
And even the small ones, such as like a late filing or something, I think we discussed this, Raz, where you said it's like if there is certain circumstances where the fine would be waived, as it is at the discretion of CIMA, effectively.
Yeah. So I mean, it's going to be fines in circumstances where you would absolutely expect CIMA to be able to have the power to fine and to take action, because the offence is sort of that egregious.
Definitely, yeah. And again,
Welcome.
and considering that the legislation will be brought in newly, again, we'll need to, you know, leave, you know, some teething time. We understand that once a regulation comes in, it comes in from day one, but it doesn't mean we just go in and start fining people. We give them time to understand the regulations. We try and get people. The main motivation for us is to get people compliant rather than anything else.
Okay. I think we're going to wrap up with Rob sort of giving us his views on, you know, the regulatory policies over ownership and control, and also touching on beneficial ownership register as well, and how that's applicable to insurance companies.
Yeah, thanks, David. I'm going to try and move through it fairly quickly because we are running out of time. So notification of changes in ownership and control. There's nothing that's actually changed here, but we thought we'd put it back on the agenda because we often see insurance managers and clients running into issues and not or failing to make notifications and seeking prior approval from CIMA for changes in ownership and control where they should be doing so. So I just briefly wanted to review the legislative and sort of regulatory framework and just give you some points to watch out for, you know, in practical situations that do tend to arise. So really the primary authority for the notification requirement comes from Section 12 of the insurance law, which reads as follows: shares totaling more than 10% of the authorised share capital of a company that is a licensee under this law shall not be issued, and issued shares totaling more than 10% of the issued share capital or total voting rights of a company that is a licensee under this law shall not be transferred or disposed of in any manner without the prior approval of the authority. So in the normal course, if you've got a transfer of more than 10% of the issued shares in your Cayman captive insurance company, you should be seeking prior approval from SEMA for that change in ownership and control. And in making that application, some of the statements of guidance and regulatory procedures come into effect, which will tell you, first of all, how SEMA is likely to evaluate, so the requirements, SEMA's requirements for evaluating whether they're going to approve that change in ownership and control or not, and the sort of documentation that's going to need to be provided in support of that change. Usually that documentation will be the fitness and proprietary documentation, personal questionnaires, and so on and so forth, that would be required in the first instance when you're making a license application. So we all get the fact that a straightforward share transfer in a Cayman Islands captive, you're going to need to approach SEMA for prior approval. But Section 12 is a little broader than that, and there are just a few other circumstances that you should watch out for as insurance managers and as clients, and talk between yourselves, as between the insurance manager and client as to what's going on. And one example is Section 12 is not just about transfers of shares. It's also about the disposal of a legal and beneficial interest in those shares. So if you dispose of the legal or beneficial interest in more than 10% of the issued shares in a Cayman captive, that will also trigger the Section 12 requirements. We don't see it very often, but an example of that might be where you have a charge over the shares of the Cayman captive for finance purposes onshore, for example, or a pledge of those shares, perhaps even as a collateral requirement under insurance policies. Not something that we see very often, but do watch out for it. Another example is where you have a cumulative transfer of shares. So it might not be a transfer of shares of 10% straight away, but as part of the same or related transaction, you might be transferring 5% of the shares during the course of November, and then another 5% during December, and then another 5% in January. And if it's all part of a related transaction, that will trigger the Section 12 provisions too, and you'll need to seek prior approval from SEMA for those transfers. Thirdly, and most importantly, and this is where we normally see things go awry, is that the trigger requirements for the 10% change of ownership and control don't just apply at the Cayman captive level. They can also apply at the parent level or higher up in any group structure. So, for example, if you have two healthcare companies in the US who both own separate Cayman captives, and there's a merger between the US entities, that's a change in control not at the captive level, but at the ownership level. That change in control at the ownership level also triggers the prior notification requirement to SEMA. And this is often forgotten about. And if you've got a merger agreement onshore, there'll often be reps and warranties in terms of that contract that say all subsidiaries and in this case the Cayman captives are in good regulatory standing and have met all necessary requirements. And of course, if you've forgotten to make the notification to SEMA and you haven't got the prior approval, you're not in good regulatory standing. So that can cause some embarrassment and some problems. Also important to know, and it doesn't come up that often, but if you do happen to have a complicated group ownership structure, SEMA will want to know of any change of ownership and control of any company where there is a 10% holding. So, for example, if you've got a Cayman captive, you've got a parent onshore that owns more than 10% of that Cayman captive, and that onshore company has its own parent that owns more than 10% of it, and there's a change of control in that ultimate parent, that still triggers a notification requirement with SEMA. And that's often forgotten about. So please just do be aware that whenever you have any change of control or transfer shares in either your Cayman captive and also in any of the parent organizations back in the US or otherwise, consult your insurance manager or your legal counsel and just make sure that you have made the notification to SEMA and you do have prior approval. Just some things to watch out for. And then just to move on to Cayman's Beneficial Ownership Register. This is something that you might have read a little bit about in the news. So on 1 July 2017, there were some amendments made to local legislation which introduced this beneficial ownership regime. And basically what it means is that Cayman Islands companies and LLCs, limited liability companies, need to establish and maintain a beneficial ownership register unless you are exempt. So unless there's an exemption that you can take advantage of. Now, this isn't a new requirement in terms of information that needs to be kept, but rather a new requirement in terms of how that information is kept and how it is made available to other government authorities, whether it's tax authorities or criminal authorities of our partner governments around the world, whether it's the US or the UK, in terms of tax information sharing agreements or otherwise. And really what's changed there is the information on beneficial ownership always used to be kept by your registered office service provider, which in the case of captives would be your insurance manager. That is going to be changed. The insurance manager will still have to keep that information, but it will be made available to a central database in the Cayman Islands in due course, and may, in certain circumstances, be provided to and exchanged with designated onshore authorities like tax and criminal authorities onshore. The good news is that the legislation specifically exempts licensees in terms of the insurance law. And you can imagine why, because as a licensee, CIMA has all that information themselves in any event and could make it available if required. So the good news is generally a captive insurance company or insurance managers will not have to maintain their own beneficial ownership register. However, there is an amendment bill that's currently being debated which introduces, which if passed in its current form, will introduce a requirement for exempted entities to file a declaration with the relevant authority to that effect. And it would appear that if you don't file that declaration, then you might be subject to a fine or penalty for non-compliance. So we're just keeping an eye on that. Now, practically what that means for captives and insurance managers, and I'll ask James what he's been doing with his clients in terms of implementation, is we think you need to, as a captive board, you need to assess whether you are indeed exempt, and you should be if you're a licensee under the insurance law. You need to document that process. You will then need to file the exemption if the bill is now passed in its current form. And then you should be reviewing that requirement at least once annually, or as necessary if there are other legislative or regulatory updates on the topic. But James, maybe I can ask how you sort of see that you need to address
I will, Rob.
that.
Yeah, just very quickly, there is one little catch here that could catch people out, which is, yes, captive insurance companies are exempt, but if that captive insurance company is owned by a Cayman Islands holding company that is not licensed, then that would fall under the scope of this. And if that holding company had ownership interest greater than 25%, which I believe is the threshold, then it comes under the scope of this, and filing would have to be made. However, going back to how insurance management companies should be handling this with their captive insurance clients, essentially, the board needs to be made aware of this. The board needs to consider it and then decide that they are effectively exempt. This needs to be documented, whether it's in the minutes or we've actually putting documents on file, memorandums on the files of the company, document that we are exempt. And then obviously, if the regulations are amended, as Rob states, we are going to have to make that annual exemption filing as well.
Okay, well, thanks, gents. I think we're out of time, so we're going to skip our last slide and just maybe take one question, one or two questions if anyone has a question at this stage.
Sorry, so going back to what you had said, Rob, about Section 12. Yes, Brandon. That obviously, that's for SPs as well as the SPC. Is that for SPs also? No, it's not. But so SPs issued SP shares. So yes, you also look at a transfer of the shares will be considered collectively. So whether they're SP shares, ordinary shares, or even preference shares. And if those SP shares do happen to represent more than 10% of the issued shares in the company and they're transferred, Section 12 applies. Thank you. Yeah.
Okay, thanks a lot.
Thank you, everyone.